A pleasant day to everyone. On the behalf of all the group members, I present to you the topic of void or inexistent contracts.
A void contract is not a legal agreement, though cannot be used to enforce a void contract. Contrary to voidable contracts, which may be annulled but are not necessarily guaranteed, void contracts are not binding. On the other hand, inexistent contracts refers to agreement which lack one or some or all of the elements. Those elements are consent, object, and cause, or do not comply with the formalities which are essential for the existence of a contract. As well have stated to Article 1409, inexistent and void contracts cannot be ratified, neither can be the right to set up the defense of illegality. I will state the following and their examples. Number one, those whose cause, object, or purpose is contrary to law, morals, good customs, public order, and public policy. For contrary to contract, it is unacceptable for A and B to have an agreement whereby A will work for B with unpaid labor as a servant as long as A has not paid with his obligation. For contrary to morals, a contract whereby A's agreements to live with B as their common law spouse without the benefits of marriage in exchange of 50,000 pesos is void since it is immoral. For contrary to good customs, A entered into a contract whereby A binds herself to slap his father. This contract is void since it is against the good customs of showing respect to our parents. Contrary to public order, a lease stipulation authorizing the use of force by the landlord to evict the tenant if the latter fails to pay the agreement upon rent is void since it violates public order. Contrary to public policy, if a condition essentially amounts to a perpetual restrictions on the right of ownership, notably the owner's right to freely dispose of his property, it is against the public policy. Such as prohibition is null and void since it is illogical and untimely, continuing to apply long after the original contract's parties have passed away. For number two, those which are absolutely simulated or fictitious. B also A. A acted as he was selling her land to his father-in-law's seat after learning that he was intending to enforce her credit. Due to the fact that the deal was just hypothetical or fake, they did not get even a single centavo for the deed of sale. She executed and kept possession of the land. There is no contract of sale in this case, as the parties did not intend to be bound upon. For number three, those whose cause or object did not exist at the time of the transaction. A sells to B a parcel of land. In the deed of sale, 100,000 pesos is stated as the price of the land. If the statement is false, then there is no contract of sale. For number four, those whose object is outside the commerce of man. If the object is outside the commerce of man, such as sidewalks, or public plazas, or public bridges, they cannot be the object of contract for any relation, but may be the object, for example, of a contract of repair. Number five, those which contemplate an impossible service. A contract is void if it is signed by a blind person or calls for the use of their eyesight. Number six, those where the intention of the parties relative to the principal object of the contract cannot be ascertained. A sold his land to B. A has many lands. It cannot be determined which land was intended by the parties to be the subject of the sale. Therefore, the contract shall be null and void, as if the parties have not entered into any contract at all. Number seven, those expressly prohibited or declared void by the law. Contracts upon future inheritance, except in cases expressly authorized by law.
Article 1410, the action or defense for the declaration of the inexistence of a contract does not prescribe. According to this article, contracts that are considered void or inexistent do not prescribe. This means that a party can bring a court action to declare it void or inexistent at any time, regardless of the length of time that has passed. Moreover, if a party wishes to enforce a void contract, the other party can always raise the defense of nullity, regardless of the time the contract was made. This highlights the importance of seeking a judicial declaration of nullity to ensure that both parties have a peace of mind and avoid taking the law into their own hands. It's worth noting that since a void contract has no legal effect, it's unnecessary to bring an action to declare it void. A party has the right to unilaterally cancel and treat it as voided. For example, Evermore, the seller, and Folklore, the buyer, entered into an absolutely simulated contract of a parcel of land. Evermore brought an action in court to recover the land only after 50 years. Is it correct for the court to dismiss the action because of the long lapse of time? No, the action cannot be dismissed by the court. According to Article 1410, the action or defense for the declaration of the inexistence of a contract does not prescribe. This means that if a contract, in this case an absolutely simulated contract, is void, a party to it can always bring a court action to declare it void, and a party against whom a contract is sought to be enforced can always raise the defense of nullity, regardless of the passage of time.
Article 1411, when nullity proceeds from illegality or the cause or object in the contract, and when the act of constitute a criminal offense, both parties A and party delicto are called equal fault, and party delicto shall be prosecuted. Moreover, the provision of the penal code's disposal to the effects instrument of a crime shall be applicable to the things or to the price of the contract. This rule shall be applicable when only one party is guilty, and the innocent one may claim what she or he given, and shall be not bound to comply what he her promised. Here's the two rules where the contract is illegal and the act is constitute a criminal offense. First, the party in pari delicto. In pari delicto, where the both parties are guilty. Example, Sarah sold to Bianca a second-hand laptop that cost 30,000, but Bianca paid only 15,000. So Sarah delivered barely the laptop without installation of the operation system. In this case, both parties shall be prosecuted and the price and the laptop shall be confiscated. And the second one is indelicto. Indelicto is where the party is only one guilty and there's a person who is less guilty. This person may claim and return what she given. And beforehand, if she or he not bound to comply the agreement or the contract. Here's the example of indelicto. When Bianca was in a good faith, she can claim the return of 15,000 pesos. If she not yet paid to Sarah, she shall be not bound to comply with her promise.
Article 1412. If the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. First, when the fault is on the part of the both contracting parties, neither may recover what he has given by virtue of the contract or demand by the performance of the other's undertaking. Second, when only one of the contracting parties is at fault, he cannot recover what he has given by reason of the contract, or ask for the fulfillment of what has been promised to him. The other who is not at fault may demand the return of what he has given, without any obligation of to comply his promise. This has rules to follow in this article are, if both parties are in pari delicto, they cannot recover what they had given under the contract. They cannot demand the performance of the undertaking or promise of the other party. If only one of the contracting parties is at fault rather, the one at fault cannot recover what he has given under the contract. and they cannot demand the fulfillment of the promise of the other. The one who is not at fault may demand the return of what he has given without the obligation to comply with his promise or undertaking the other. Example, when the parties are both in pari delicto and the cause of contract is unlawful or forbidden, but no criminal offense. Eve agreed to live as the common law wife of Xavier in consideration of the promise on the part of Xavier to donate a purple buff to Eve. In this case, the promise of Xavier has for its consideration an immoral act, which does not constitute a crime. Hence, there can be no recovery by one against the other, or they cannot ask the fulfillment of the other promise.
Article 1430. The interest paid in excess of the interest allowed by usury laws may be recovered by the debtor with interest thereon from the date of the payment. The legal interest is 6% per annum. However, in this case, if the interest is excessive, the debtor may recover not only the interest in excess of that allowed by law, but also he may recover the entire interest paid from the date of the payment. For example, the interest is 10% per annum, but the legal interest is 6% per annum. So the debtor, he may recover not only the 4% of the interest in excess of that allowed by law, but also he may recover the entire excessive interest, which is the 10% per annum.
It is stated in Article 1414 that when money is paid or service delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished or any damage has been caused to a third person. In such case, the court may, if the public interest will thus be subserved, allow the party who repudiated the contract to recover his or her money or property. However, this article can only be applied if its requisites are followed. Number one, the contract is made for or from an illegal purpose. Second, the contract is repudiated before its purpose has been accomplished or any damage has been caused to a third party. And third, the court considers that by allowing this recovery to happen, the public interest will be subserved. Let's try to make an example. Let's say that for 25,000 pesos, A promised to kill C for B. B agreed, and he gave the reward in advance. However, before A could kill C, B changed his mind and he withdrew from their agreement. In this case, the court may allow B to recover his payment of 25,000 pesos from A since the purpose of their agreement or their contract has not been accomplished and no damage has been caused to C.
Article 1415, where one of the parties to an illegal contract is incapable of giving consent, the court may, if the interest of justice so demands, allows recovery of money or property delivered by the incapacitated person. This article is another exception to in pare delicto. As to what was said earlier, in pare delicto, both parties are guilty of each other. This exception entails that one of the party in an illegal contract is incapable or incapacitated to give consent. The court allows proceeds to recover their money and property if interest of justice so demands. Example, if X is insanely entered into an illegal contract and give his property, the court allows X to recover the property if the interest of justice so demands. In Article 1327 states that minors, insane, demented, and deaf mutes who do not know how to write is a person cannot give a consent. Then if they enter into an illegal contract, what they give, such as money or property, may recover as Article 1415 said that the court allows them to recover.
Article 1416. Article 1416 states that when the agreement is not illegal per se, but is merely prohibited and the prohibition by the law is designed for the protection of the plaintiff, he may, if public policy is thereby enhanced, recover what he has paid or delivered. Article 1416 is another exception to the rule that where both parties are in pari delicto or in equal fault, they will be left where they are without relief. The plaintiff can still recover what he has paid or delivered as long as the agreement is lawful, or the agreement is not illegal per se but is merely prohibited, and the prohibition is designed for the protection of the plaintiff. Public policy would be enhanced by allowing the plaintiff to recover what he has paid or delivered. It applies only to those contracts which are merely prohibited in order to benefit private interest. It does not apply to contracts void ab initio or contracts void from the beginning. In prohibited sale of land, a land sold in violation of the constitutional prohibition against the transfer of lands to aliens may be recovered. Accordingly, a contract whereby an alien is given not only a lease but an option to buy a parcel of land by virtue of which the Filipino owner cannot sell or otherwise dispose of his property, this to last for 50 years, is a virtual transfer of ownership and circumvents the constitutional ban against alien landholding. A sale of land to a dummy in violation of the Constitution is void for being contrary to public policy. Another example. A donated to B everything she owned, leaving nothing for herself. Since public policy is hereby enhanced, A will be allowed to recover necessary for her own support and the support of her relatives.
Article 1417, when the price of any article or commodity is determined by statute or by authority of law, any person paying any amount in excess of the maximum price allowed may recover such excess. This article refers to the ceiling price or ceiling law, whereby the statute or by competent authorities such as the executive order of the President determines or fixes the maximum price of any article or commodity. The purpose of this law is to prevent profiteering or black marketing, which is against the interests of the people. Any payment made more than what has been determined may recover such excess. This usually applies to basic needs and during an emergency or crisis. Prices of commodities such as canned goods, noodles, rice, and etc. Example, suppose by executive order of the President, the price per kilo of rice of a particular brand and quality has been fixed at 30 pesos. If a person pays 35 pesos for it, he can recover the excess of 5 pesos.
Article 1418. When the law fixes or authorizes the fixing of the maximum number of hours of labor and the contract is entered into whereby a laborer undertakes to work longer than the maximum thus fixed, he may demand additional compensation for the services rendered beyond the time limit. In accordance with the Presidential Decree Number 442, also known as the Labor Code, the established working hours per day is only 8 hours. The article mandates the right of a laborer to demand an additional payment for services rendered beyond the fixed working hours. It is applicable for all non-profitable and profitable establishments except the following: government employees, managerial employees, field personnel, members of the family of the employers who are dependent upon him for support, domestic helpers, persons with personal service of another, workers who are paid by results. Example, Lienzo is working as a security guard in a private establishment. He has 12-hour duty per day. Therefore, he has the right to ask for compensation for the services rendered beyond the fixed working hours.
Article 1419 of the Philippine Civil Code. When the law sets or authorizes the setting of a minimum wage for laborers, and a contract is agreed upon by which a laborer accepts a lower wage, he shall be entitled to recover the deficiency. Article 1419 states that if one employee receives less than the minimum wage rate, he can still recover the deficiency with legal interest, and the employer shall be criminally liable. However, if the laborer agreed to receive wages lower than the minimum wage fixed by law, he is not barred from recovering the deficiency.
Such contract or agreement is void under the minimum wage law, which provides that no worker or organization of workers may voluntarily or individually or collectively waive any rights established under this act, and no agreement or contract, oral or written, to accept a lower wage or less than any other benefit required under this act shall be valid. For example, A owned a little coffee shop with B as his employee, and both parties signed the contract. When the payday comes, B got frustrated as he received only the amount 300 pesos per day instead of 500 pesos. Therefore, B can recover from the deficiency that he received from A. However, if B agreed to receive a wage lower than his minimum wage, which is 300 pesos per day, then he cannot recover his deficiency as it is already fixed by the law. Another example, S is an employee of Jollibee, has voluntarily agreed under contract to receive 200 pesos per day, wage lower than the minimum wage fixed by law. Regardless of fact, he is not barred from recovering the deficiency. Such contract or agreement is void under the minimum wage law.
Article 1420. In case of a divisible contract, if the legal terms can be separated from the legal ones, the latter may be enforced. It only means when a contract has multiple clauses, terms or conditions, does the article come into play. The provisions that can be separated from the ones that are valid, even if some of them are illegal, must still be effective and enforced. The rule of divisibility or separability cannot apply in two situations. 1. When the contract's nature demanded indivisibility. 2. When the parties intended the contract to be fully indivisible, the rule of divisibility or separability cannot be applied. Remember that divisibility between contracts and obligations differ from each other. Divisibility of the former talks about the contract's cause, while the divisibility of the latter refers to prestation or object. Example, Mark agreed to sell and deliver to Jules certain amount of illegal cut log, including the towing vessel to be used. The sale of the illegal logs may be avoided, leaving the transaction on the towing vessel enforceable. However, the intertransaction is void if the parties expected the transaction to be complete, meaning that without the logs, the vessel would not have been purchased. In a loan agreement, the borrower used a fictitious title to execute a real estate mortgage as a security for the loan payment. The loan is still legitimate, but the mortgage is null and void. Invalid terms of the compromise that stand alone from the rest of the agreement and that are easily severable without going against the parties' clear intention, do not render the entire contract invalid.
Article 1421 states that the defense of illegality of contract is not available for third persons whose interests are not directly affected. If the contract is voidable or unenforceable, third persons are not allowed to bring an action to annul or to assail the contract. However, if the contract is void or illegal, even the third persons may avail the defense of illegality of contract and set up its own nullity, for as long as his interest is being affected, directly affected. Let's try to have an example. Let's say that Harry, the husband, sold his parcel of land to Winnie, his wife. Under the law, husband and wife cannot sell property to each other and therefore is considered as illegal and void. Under Article 1421, if Troy, a third person, became a creditor of Harry before all the transaction happened between the husband and wife, Troy can question the sale for the reason that his interest is directly affected.
Article 1422. A contract which is direct result of a previous illegal contract is also void and inexistent. This provision is based on Article 1298 explains that void obligation cannot be novated since there is nothing to novate. In the first place, void contracts are those that have defects, like contracts
contrary to law and morals and such. It produces no effect or it does not perfect a contract. Then if a contract arises from illegal contract, it is considered to be void and inexistent. Example, X made up a contract with Y to sell a parcel of land in which the location of the land is not existing. Later on, Y sells the parcel of land to Z, and he found out that the location of the land is not existing. Here, the first contract is void, since the contract arises from absolutely simulated. Therefore, the contract of Y and Z is also void as to what 1422 says. The injured party can sue X since the contract is made by X.
This case is about Ligwes versus Court of Appeals. Facts about the case. The case began with a complaint filed by a petitioner appellant against the widow and the heirs of the late Salvador T. Lopez to recover a parcel of 51.84 hectares of land in the province of Davao. The defense interposed that the donation was null and void for having an illicit cause or consideration, which was the plaintiff's entering into marital relations with Salvador T. Lopez. The Court of Appeals found that when the donation was made, Lopez had been living with the parent of appellants for barely a month, and that the donated land originally belonged to the conjugal partnership of Salvador P. Lopez and his wife, Maria Ngo. The Court of Appeals rejected the appellant's claim on the basis of the well-known rule in pari delecto non oritur, actio, as embodied in the Article 1306 of 1889. Issue: whether or not that the donation was void to an illegal cause. The answer is yes. Next, whether or not that the parties are in pari delecto. The answer is no. Rulings of the case. The deed of donation was inoperative, null, and void, because the husband, Lopez, has no right to donate a conjugal property to plaintiff's appellant, and because the donation was tainted with illegal cause or consideration. Salvador P. Lopez was not moved exclusively by the desire to benefit appellant Conchita Ligwes, but also to secure her cohabiting with him so that he could gratify his sexual impulses. The Court of Appeals erred in the applying of pari delecto rule to the present case, as it cannot say that both parties had equal guilt when considering that the appellant was a mere minor, 16 years of age when the donation was made. Additionally, the rule that the parties to an illegal contract, if equally guilty, will not be aided by the law, but will both be left, whereby if finds death, had been interpreted as barring the party from pleading the illegality of bargain, either a cause or action or as a defense.
This is an interesting case between Philippine Banking Corporation, representing the estate of Justina Santos E. Canon Faustino, versus Louis She in her own behalf and as administratrix of the intestate estate of Wong Heng. Facts of the case. Justina Santos and her sister own a piece of land in Manila, while Wong Heng is a longtime lessee of the property. Eventually, Justina became the owner of the property. Already in old age, Justina trusted various tasks to Wong, including the delivery of rental payments to her property. In grateful acknowledgement of his personal services, Justina executed a contract of lease in favor of Wong. Later, a separate contract for option to buy the leased property was executed, subject to a condition that Wong obtain a Philippine citizenship. She even extended the terms of these contracts. The lease term to 99 years and the term of the option for 50 years. However, Justina appeared to have a change of heart and claimed that the contracts were made through machinations and inducements practiced by Wong. Thus, Justina directed her executor to secure the annulment of the contracts. A complaint was then filed before the Court of First Instance of Manila on the said grounds, and asked the court to direct the Register of Deeds of Manila to cancel the registration of the contracts. Wong denied having taken advantage of the trust and confidence given to him by Justina. The Court of First Instance rendered its decision nulling all the contracts, except the lease contract, and condemned Wong to pay Justina the unpaid rentals. From this judgment, both parties appealed directly to the Supreme Court. The issue here is whether or not the contract entered by Wong and Justina were valid. The ruling for this case is no. The contracts, when taken singly, show nothing that is necessarily illegal, but considered collectively. They reveal an insidious pattern to subvert by indirection what the Constitution directly prohibits. Citing Crevenco versus Register of Deeds, the court espoused that a lease to an alien for a reasonable period is valid. So is an option giving an alien the right to buy real property on condition that he is granted Philippine citizenship. But if an alien is given not only a lease of but also an option to buy a piece of land by virtue of which the Filipino owner cannot sell or otherwise dispose of his property, this to last for 50 years, then it becomes clear that the arrangement is a virtual transfer of ownership whereby the owner divests himself in stages not only of the right to enjoy the land but also of the right to dispose of it. Further citing Crevenco, the court said that under the Constitution, aliens may not acquire private or public agricultural lands, including residential lands.
This is the case between Leonardo Cabal and Ramon Nicolas versus Villanueva Cabal and others. Facts of the case. Alejandro Cabal and Felicidad Balsabas owned a parcel of land situated in Barrio Tanglad, Manguyod, Negros Oriental, containing an area of 18.15 hectares, more or less described in Tax Declaration Number 15856. By a deed of absolute sale dated July 6, 1971, his parents transferred for 2,000 pesos ownership of the said land to him, who was then married to Justiniana Lipahan. Subsequently, he executed on April 19, 1990, a deed conveying the same property in favor of Leonardo. Villanueva was later to claim that while April 19, 1990, a document he executed now appears to be a deed of absolute sale, purportedly witnessed by Baez City Trial Court Clerk Carmelo Cadalit and his wife La Corte. What he signed was a document captioned Lease Contract. Villanueva thus filed on October 11, 1993, a complaint before the Dumaguete RTC against Leonardo and Ramon Nicolas, to whom Leonardo in turn conveyed the property for annulment of the deed of sale. Villanueva on his stand claimed that he did not know the contents of the contract and only happened to read the title of the lease contract. The trial court found for the therein defendants herein petitioners, Leonardo and Ramon Nicolas, and accordingly dismissed the complaint. Villanueva and others thereupon brought the case on appeal to the Court of Appeals, which reversed the trial court, it holding that the deed of absolute sale executed by Villanueva in favor of Leonardo was simulated and fictitious. Leonardo and Nicolas then petitioned on the Supreme Court for review on certiorari. The issue is whether or not the deed of absolute sale is valid. The ruling of the court, it was incumbent on the respondent Villanueva to prove that he was deceived into executing the deed of absolute sale, except for his bare allegation that the transaction was one of lease. He failed to adduce evidence in support thereof. His conjecture that perhaps those copies of the deed of sale under the documents which signed the contract of lease must fail, for facts, not conjunctures, decide cases. Villeneuve failed to prove his allegations, for he failed to adduce evidence to support his claims of simulation and lack of knowledge as to the nature of the deed. Leonardo's witness, the drafter of the actual deed, on the other hand, was able to prove that the deed was duly drafted, read, and signed by Villeneuve.